by which a particular insurance policy will be covered, be interpreted. There are a couple recent exclusions that were introduced after the SARS, H1N1, and Ebola outbreaks, covering losses the result of or caused by viruses or bacteria. It's very important to determine whether those exclusions are contained in policies. There are standard form exclusions, but from what I've seen, they haven't been introduced throughout the not all markets are using those exclusions yet. And there's not a lot of interpretation of those exclusions. It's also absolutely important to pay attention to other key conditions, limitations, and exclusions within the policies. These could be from the range of classic contamination or pollution exclusions. Conditions such as trigger of coverage are going to be key. The issue as to whether or not there's been an occurrence in a general liability policy, or whether or not there's been property damage in a property policy, will be a key area of dispute. And of course, it's always important to pay attention to policy conditions such as notice. As with any coverage issue, it's the particular facts and circumstances of a claim are going to make a major difference in most coverage issues. For example, something we'll be talking about up shortly is whether or not a closure order was prepared that recited the need to prevent or limit risk to property, or whether or not it was issued on another basis. That could be an important issue, factual issue. So with all of this in mind, there's certain to be long-lasting coverage disputes. And the first area of insurance policy coverage that we'll be taking a look at is commercial first-party property insurance.
Yep. Thank you, Dan, for all that. So as I think most of you probably know, that this property insurance coverages come in several different flavors. Oftentimes they come as part of a package policy purchased by an insured, and those typically include all risk property insurance. We also have policies that are sometimes standalone policies that cover specific risk. And an issue that's going to come up with respect to any of these policies is whether you've got a direct physical loss to covered property that was caused by a covered peril. There are a couple different ways that different jurisdictions handle this sort of broad question of whether there's been a direct physical loss. But in general terms, it requires a distinct, demonstrable physical alteration of property for there to be a direct physical loss. In some jurisdictions, there's been case law saying that whenever a property has been rendered completely uninhabitable, then that test is met, so that you've got you've met that requirement to have a direct physical loss to covered property. But that's not every jurisdiction has dealt with that issue in a way that's necessarily going to be helpful. But even if the jurisdiction has, you're going to have some other issues. The first is, well, who decides the property is uninhabitable? In many cases, you may end up having expert testimony, and there may be one expert says that no, you can't, nobody can go in this property. It's completely unsafe for everyone to be in here. Another expert might say, well, if people take certain precautions, precautions that, maybe not to the extent we're doing now, but we all generally have to take in our everyday life, then yeah, people can still safely use the property. If they're wearing masks, washing their hands, doing social distancing, then yes, you can still use the property, so it's not uninhabitable. So you're going to have those kinds of expert disputes.
And I think, Joe, we talked about this as a group, and we didn't think that this was going to be where a lot of the action on these COVID type claims are. Do you agree with that?
Yeah. So the property coverages are going to relate a lot. A lot of those claims are going to be claims for cost to remediate or clean up premises so that a business can open back up and feel confident that they aren't going to give coronavirus to anybody. So those, in terms of the dollar amount, there will be claims here, but they're not going to be on the same scale of the claims that we're going to get into in a minute, and that's the business interruption claims. And I believe Tiffany has more on that.
Yes, so there are several different variations on business interruption. You can have regular business interruption. There's the contingent business interruption, which occurs when a supplier has to suddenly stop work. The government authority coverage, which is, as someone mentioned earlier, when an order comes down and restricts access to the property. And I think, Dan, you have a good policyholder perspective on these.
Oh, thanks, Tiffany.
Sure.
Yeah, the business interruption coverages are likely to be where much of the initial claims activity takes place, because these are the issues that are really going to most immediately have tangible adverse impacts for businesses. And of course, the classic business interruption coverage is the basic: there has been some form of physical loss or damage to the insured premises that results in a stoppage or interruption in business. The loss must take place because of a covered risk or cause of loss. And as Joe had mentioned in connection with first-party property insurance, this is likely to be a difficult issue, whether or not the presence of the virus in some property is a covered cause of loss, and it's going to be a matter of much dispute. And I think it's going to be very important to look for the appropriate, to look at the way different jurisdictions are going to interpret that. The more sophisticated and very often an optional coverage in a lot of basic property policies is contingent business interruption coverage. And this is the coverage that applies when there has been a covered cause of loss at a property on which the insured depends to conduct its business. A supply source, it could be an access road. You know, it varies, and it's very important to look at the conditions in these policies to see whether there is some temporal or some spatial limitation on what can count as a contingent business. As with traditional business interruption coverage, this coverage, the loss that's covered is lost business income, the continued expenses of maintaining operations, continuing expenses, things like rent and payroll, and then the extra expenses of maintaining operations in light of the interruption.
And Dan, I feel like this is something that came up a lot after 9/11, for example, when businesses in Lower Manhattan, you couldn't access Lower Manhattan, right?
Exactly. No, these are the kinds of claims that absolutely came up after 9/11, and there it was relatively clear that there was there was a damage that made it impossible to access. And in addition, besides that, there was also the next slide, which touches upon governmental authority coverage. In 9/11, there were rules issued by the city of New York, by the federal government, limiting access to Lower Manhattan during while in the aftermath of that tragedy. And that's going to be, and that's certainly, given the closure orders and the stay-at-home orders that have been issued by various governmental entities, if that coverage is sort of an extension of the business interruption coverage is available in a particular first-party property policy, that's likely to be a significant area of claims activity. With this coverage, it's going to be very important to look at the nature of the governmental order, whether or not the order specifically identified property damage and the avoidance of property damage as a basis for the order, or whether or not it was simply a broader to avoid physical bodily injury. That will make a difference in the coverage analysis. And there are multiple other conditions and limitations on this coverage, including, again, distance, the type of location that can be involved, that really, as with all of these policies, make the particular facts and circumstances of a claim paramount. It's what's key in all of these coverage issues is taking the language of the policy and applying it to the particular facts and circumstances of any particular claimant, either determine if there is coverage or there isn't coverage. And, and we've actually started to see some claims develop already, which will lead us to Tiffany's slide.
Yes, thank you. Just a moment. So the first case we're going to be talking about is French Laundry. We're going to follow that up with Oceana Grill, and then we'll go to Chickasaw Nation. These three cases were declaratory judgment actions that were filed in state court, and they were all filed before claims had already been submitted. The last case we'll talk about is Big Onion Tavern, and this case was actually filed after the claims had already been submitted and denied. So there's an interesting angle to that. And all of these relate to coverage under the governmental authority provisions. But the plaintiffs have taken very different strategic approaches. Just in the interest of time here, we're not going to get bogged down in the details of each case. We're going to talk a little bit more about the major strategy decisions. And if you need any case citations, just let us know at the end and we can provide you with those. So we'll go into French Laundry. This case, like I said, it was filed in state court in Napa County, and it stems from the closure of Thomas Keller's famed restaurant, the French Laundry, due to a shutdown order from a Napa County health officer. So here, to try to satisfy the physical loss or damage requirement, the plaintiffs are making a few different points. They claim that COVID-19 has physically impacted property and physical spaces around the world. The virus physically infects and stays on surfaces for up to 28 days. Other countries, including China, Italy, France, and Spain, clean and fumigate areas before they're allowed to be reopened to the public. And perhaps most importantly, they also point to the language of the order itself, which states in relevant part, this order is issued based on evidence of the increasing occurrence of COVID-19 throughout the Bay Area, increasing the likelihood of occurrence of COVID-19 within the county, and the physical damage to property caused by the virus. So I'll open this up to my panelists. Do you think that this may satisfy the physical loss or damage requirement?
Well, just based on the facts alleged in the complaint, this is an example of why the particular language of the policy and the particular factual circumstances of any claimant's loss is so important. The policy is alleged here did not contain a virus or bacteria exclusion, but actually extended coverage to loss or damage resulting from a virus. In addition, the order issued by the relevant governmental authority here did specifically recite the risk of property damage and the need to order a closure in order to prevent additional property damage. So that this really illustrates why the status of a claim can be very different depending upon the particular facts presented.
Joe or Jolie, do you have any thoughts?
You know, I was just going to add, not only is the facts important, but also we talked about this a little bit, you know, it's going to depend on the choice of law. We have these insurance policies that are being issued in certain states, but that doesn't necessarily mean that that state's law is going to apply. And depending on where it's filed, whether it's in state court or federal court, these courts have an analysis that they have to go through to determine whether or not they would apply the law where it was issued or, you know, where it was brought. So, you know, those are other factors that are going to really be significant when determining whether or not there's coverage under the policies.
Yeah, I'll just add that what Dan and Jolie said both is absolutely right, that these cases are all going to be not just fact specific, but because insurance law as a general matter is governed by state law almost exclusively, then it's going to be law specific as well, and that choice of law analysis is in many times going to be very important.
Okay, so let's move on to Oceana Grill. This case is very similar to French Laundry, as actually the same attorney is representing both parties. It was filed in state court in New Orleans just a few days before French Laundry. So in this case, the plaintiff likens COVID-19 to the intrusion of lead or gaseous fumes, which Louisiana courts have interpreted constitute a direct physical loss that would have to be remediated. Do you think that the analogy of COVID-19 to the lead or gaseous fumes is persuasive?
And I'll go back. I think what I was talking about a little bit with the property coverage. If you've got a property that is rendered uninhabitable by the presence of coronavirus, then maybe, but I don't think coronavirus is the same as lead or gaseous fumes. I think there are measures that we all take in our everyday lives that can prevent an inevitable injury that might be the result of lead or particular gas fumes, and that we can prevent that in the case of coronavirus. So I'm not sure it's the exact same, but I think you're going to have a fight between experts on both sides, trying to say that it is the same because it's rendered the property uninhabitable, and others saying no, you can do all these things to mitigate against the risk and still use the property.
Exactly. This is an example of a case where it's very likely that the selection of the particular forum and the analysis of how a particular forum interprets conducts insurance policy interpretation likely played a role. Seeing that a somewhat analogous broad environmental exclusion was held not to apply gives a claimant a possibility to argue that, well, a viral exclusion won't apply here either, or that this will somehow, in the absence of a viral exclusion, that presence of a virus will be held to constitute physical damage to property. So it's really, it's a matter of selecting Louisiana because Louisiana tends to interpret these things a particular way. And it just points to the importance of that factor.
Well, and when I was reading Tiffany's description of this case, it sounded to me, and Dan and I both have some gray hair here. I'm lucky enough to cover mine up with dye. It sounded like Legionnaire's disease in a way, but I think you don't agree with that, right?
Well, I mean, depending on which perspective one was to take, I would certainly make the argument that the presence of the virus, and given how uncertain we may be as to how long it lasts, and simply that it would arguably be very similar to Legionnaire's disease in terms of being damage to property. I think insurers would take a different view on that, which is why this is going to be, I think, picking a favorable forum is going to be important.
I think you made an analogy to asbestos at some point during our chat.
Oh yeah, well that is simply, I think, how wide-ranging these disputes could be. I mean, given the amount of economic damage here, this could be the business interruption version of the asbestos bodily injury claims. Which is another reason why this is going to be these are going to be hotly disputed issues, I think, for years to come.
Which, if I might add, that means that motions for summary judgment aren't going to be easily granted. So these are facts that are going to really need experts on both sides. And we can see that the insured will come up with creative ways to try to find coverage when there isn't specifically indicated in the policy.
Okay, so moving on to Chickasaw Nation casinos. In this case, a Native American tribe that runs casinos has sued a group of insurance companies. This is in Oklahoma State Court, asking for a declaration that the losses and expenses from the pandemic shutdown will be covered by their policies, which are wide-ranging and do include civil authority interruption. So this complaint contains very few allegations. The nation essentially alleges that as the direct result of the pandemic and infection, its property has sustained direct physical loss or damage and will continue to do so. Because the property has been damaged, it now cannot be used for its intended purpose. That is essentially the complaint right there. So to my panelists, do you think it's a good strategy to file a bare bones complaint at this point?
Yeah, I think
I'll just
it's.
chime in a
Go
quick
ahead,
comment.
Jollibee.
Go ahead. Go ahead. Okay. I was just going to chime in. I know, I don't think it's necessarily the best strategy, but I will tell you, as a defense counsel, I see over and over plaintiffs' counsel doing this all the time. And I think that, while we can file motions to dismiss, what happens here in Florida is that all they need to do is meet the minimum requirement of a pleading, and they get their case in. It doesn't necessarily mean that they're going to win on the issues, but we all know that the pleading requirements are not that stringent, that anyone can file a bare bones complaint, and once they're alleging the essential elements of what they're trying to prove, that they'll be allowed in and the case will continue. So I can see that happening a lot with these cases because no one really knows what to say. No one knows what to allege because this is so new. So it'll be interesting.
Yeah, I think it kind of cuts. It has the potential to cut both ways depending on the particular factual issues. It's not uncommon in insurance coverage cases for you to have a relatively bare bones complaint, but it incorporates the policy by reference and gives enough facts about what the plaintiff is alleging is or isn't covered that allows a court to consider any issues of law on something on a relatively early motion for judgment on the pleadings. But as Jolie was saying, a lot of these claims are likely to be fact specific, and plaintiffs that allege a bare bones but presumably sufficient complaint maybe putting themselves in an advantageous position to avoid an early disposition and at least get themselves into discovery.
And certainly this may also be an example of a plaintiff looking for a potentially favorable jurisdiction. Having litigated in Oklahoma, state court in Oklahoma, it can be difficult to be an outside large financial entity. I was representing a commercial bank that was being sued in a banker's professional liability claim in state court in Oklahoma. And the court was very favorable to the local guy rather than to the outside bank. And that might be part of what's driving a lawsuit like this. Get in court right away, pick your forum, and hope for favorable treatment. It's not an unusual strategy for the plaintiff to take.
So the last case we'll talk about is Big Onion Tavern, and this was filed in Illinois federal court, unlike the other cases which were filed in state. This is by a group of restaurants and movie theaters that purchased policies from the same insurer. Unlike the other actions, which were filed before any claims had been submitted, this action was filed after claims had already been submitted and denied. And here the plaintiffs are seeking money damages for breach of contract and bad faith denial. So an interesting wrinkle in this case is that the plaintiffs contend that the insurer engaged in bad faith claims handling by issuing blanket denials for losses related to the closures without conducting any meaningful investigations as is required by Illinois law. They also allege that the CEO of the insurance company circulated a memo to its agency partners indicating that the insurer would likely not be providing coverage in connection with the losses caused by the government-ordered shutdown. So if these allegations are true, do you think that they're going to have an effect on the outcome here?
Well, I'm going to say,
yeah,
as somebody who's not an insurance lawyer, this doesn't sound very easy for summary judgment.
And bad faith allegations are something that I know that insurance companies don't like them, and it's important I mean, you can be assured that policyholder side lawyers will be looking for excuses to make bad faith allegations, and the suggestion that there was some sort of carte blanche, across the board, just deny these claims without any analysis. If that's what that memo said, that's something that it can be expected that policyholder lawyers will jump upon. So I think for my fellow panelists, that's an important consideration of how these claims are handled by insurers. And how claims adjusters are prepared to go out into the field to deal with these claims, because it is this sort of just across the board denial, no questions asked issue will come up if that's indeed the case.
Yeah, and I'll add to that. I don't know anything about the circumstances of this particular case, but it would be surprising to me if a higher up in an insurance company had written a memo directing that these claims be denied on a blanket basis. However, I will say that in insurance companies, in a situation like this where everybody in the organization is going to be facing some brand new claims that the vast majority of them have never seen anything like before. So it's incumbent upon the insurance company to provide some guidance to the people in their organization so that they can make principled decisions on claims that come in. And one of those issues may be, we're seeing a lot of these types of claims. In a lot of cases, these aren't going to be covered for these reasons. There may be other cases where there may be coverage, but certainly insurance companies, insureds attorneys can often make a big deal about words that the insurance company chooses to communicate to its adjusters and in trainings and places like that. But the insurance company is going to have an obligation to get its people up to speed on how it wants to handle these claims. But it does need to be careful about how it does that, keeping in mind that these penalties for bad faith and in some case availability of treble damages are very serious penalties.
Yeah, it's interesting to me that we've seen this many cases on these business interruption type issues already. I know we started this a bit ago. It's possible that there have been even quite a few more. But we do have other kinds of policies that may be implicated in insurance issues related to the pandemic.
Yes, we do. Thank you, Michelle. So one of the other coverages there are likely to be some claims made under our general liability policy, including a personal injury type coverage. So if you can imagine an elderly gentleman goes to the drive-thru at a restaurant and later dies from coronavirus, his family decides that he contracted it at the restaurant and sues the restaurant for wrongful death. So what are the implications of a suit like that? The first thing to say is that from a defense of that kind of claim perspective, you're going to have issues with causation. If coronavirus is everywhere and anybody that walks outside without wearing a face mask is going to end up in the ICU, it's going to be hard to say that it came from this particular restaurant. There's also going to be an issue of assumption of the risk. Anybody that's cut on a television in the last 4 weeks knows that you're supposed to stay at home. So if you go to a restaurant, are you assuming the risk of contracting coronavirus and the injuries that may come with that? From an insurance coverage perspective, I think one of the biggest issues here is going to be whether or not a circumstance like that is an occurrence. As everybody knows, an occurrence is helpfully defined in most CGL policies as an accident. And what that means has been litigated since the early 1800s, and I'm not sure we know much more about what it means now than they did then. But nevertheless, we're going to keep trying. In some states, whether or not something's an accident essentially depends on whether or not the insured intended for their action or inaction to result in a particular injury. But a lot of states have taken this position that, well, it's really hard to specifically prove that somebody intended injury to happen. So we'll imply intent in certain circumstances, including where a particular action is substantially certain to result in injury. And that's the case in North Carolina, at least, and I know some other states as well. So in a case like this, as an insurer's coverage attorney, I think I could make a darn good argument that the restaurant, by choosing to remain open, it was substantially certain that decision would result in some injury, would result in the spread of the disease and injury to somebody. There are, in addition to that, there are a couple of exclusions that could potentially apply. One is the pollution exclusion. I think there could be some litigation in this area about whether the pollution exclusion applies. In a lot of jurisdictions, courts say that, well, it only applies to traditional environmental pollution. And that is probably in the case of traditional environmental pollution. But I think if you drill down the language, there's an argument to be made there that coronavirus is a pollutant, and that injuries arising out of that pollutant are within the exclusion. In a lot of jurisdictions, I don't think the pollution exclusion is going to get you there, but in some jurisdictions it may. There are a lot of policies that include fungi or bacteria exclusions. The problem there is that coronavirus is a virus and not a bacteria. In sort of the post-SARS H1N1 world, there have been some insurance forms that would sort of expand that to include viruses. I don't think these have been widely adopted, but they are out there, and there are also some exclusions out there for communicable diseases. Again, I don't know that those have been widely adopted in a lot of different insurance policies. Under personal injury coverage, I think the exclusion, or excuse me, the claims you might see here are imagine that a neighbor goes on Facebook or Nextdoor and says that the guy right down the street has coronavirus, and the guy right down the street files a lawsuit saying that files a defamation lawsuit saying that the neighbor accused him of having a loathsome disease, when in fact that was not true. So for these type of claims, obviously to something like that, the truth is always a defense. But from an insurance perspective, you're going to want to look at whether the insured made this statement knowing it was false or without any basis for making the statement at all. There may be some applicable exclusions that would apply in that case.
Thanks, Joe. As with any liability coverage, it's a matter, we're going to have to wait to see what kinds of claims are eventually brought. But I think it's conceivable that there are some industries that may tend to look to their insurance more for these sorts of bodily injury, property damage, personal injury claims. In particular, the transportation industry and cruise industry very likely will have maybe a stronger argument for coverage than some other types of policy holders. And I expect, and it will, because there the argument is, well, there are people constrained inside a tube or inside a particular place, and if somebody has the illness, in essence, everybody winds up getting the illness, which might address some of the causation issues. And so it'll be interesting to see how claims play out under the general liability policies. And this is actually conceivably, just thinking of how things might play out in the long term, this is an area in which the analogy to asbestos actually might be interesting in dealing with causation. The way the causation played out in the asbestos coverage cases, it wound up almost being a sort of market share. Well, where were you when, how many of these different businesses did you happen to touch? Kind of analysis to address causation. And if there are enough cases, it's conceivable that some folks could take that approach to address the causation issue, which would raise a whole set of other issues and result in a lot of very nasty litigation, very likely. So this could be an area that becomes important for claims activity.
And one I hadn't even thought of until our very esteemed panel mentioned it was D&O or professional liability.
Yeah, in the D&O area, I think there are a myriad of different claims that we could see coming out of this. One would be like a securities type claim, and obviously these D&O policies are generally not standard form policies, and every insurer has different forms, and a lot of times for these big policies they can be specific to a particular insured. But some of the claims you're likely to see securities claims. Say a CEO goes on NBC Nightly News and announces that he's got his company has developed a cure for coronavirus. Next day, their stock jumps 300%, and then a week later, it turns out that wasn't true, and a bunch of lawsuits get filed. That CEO may be looking for coverage under his D&O policy. Another claim that might come up is allegations by the owners of a company that the company's leadership failed to take steps to either prevent or mitigate the business losses that resulted from the pandemic, and this may include a claim of failure of the leadership to procure appropriate insurance to cover these types of situations. So for D&O insurance generally, it includes coverage for the insurer's liability for wrongful acts that were done within the scope of their duties for the company. There are a couple of exclusions that like I said, all these policies are different. They all have different exclusions, and they all use different language for the exclusions. But all these policies will have a bodily injury exclusion, so you're not going to be looking for bodily injury coverage under a D&O policy. Most of them also have a dishonest or criminal acts exclusion. So if the CEO knew for a fact that they did not have a cure, and if that wasn't true, he's probably going to be out of luck trying to get coverage under that policy. Some of these policies also have an exclusion for failure to procure insurance. So again, this is where you have to go and look at the policy and see what's in there. There are some really important notes about directors and officers coverage, especially for insurance attorneys out there, and that is that these are claims-made policies. So that's claims made versus an occurrence-based policy. It's different than a CGL policy. So with the claims-made policy, like most of these D&O policies are going to be covered, you have to have a wrongful act within the coverage period and a claim brought because of that wrongful act within the coverage period. I would say coverage period, most policies are going to, well, at least most policies should, or if the insured has a good enough insurance broker and attorney, these policies are going to include a retroactive date, so they'll cover claims arising out of wrongful acts that occurred before the policy inception date. And they will also include an extended reporting period so that you can get coverage for claims arising out of wrongful acts that occurred during the coverage period, but for which a claim was not brought until after the coverage had ended. Some policies may also allow for to give notice to the insurer by a notice of circumstances, meaning that you don't actually have to have received a specific claim yet, but you know that something's happened and you know you're going to get sued. You can go ahead and file, depending on the policy, you may be able to file a notice of circumstances, which would preserve your coverage for that particular wrongful act, even if the policy subsequently lapsed.
I've represented brokers in real estate contexts, and that notice issue is really, really important in these types of policies.
It absolutely is, Michelle, and there should be planning that goes around when to provide notice, particularly in what one could suspect that there's going to be a changing D&O market as underwriters begin to think in terms of whether or not there are going to be claims arising out of all of this starting to come. And it's conceivable that some corporate insureds will decide to provide a notice of circumstances early, given the risk that there will be claims in subsequent years, because of concern that, well, those subsequent year policies might now start incorporating exclusions that weren't contained in the current policies. For things like liability resulting from virus or from widespread pandemic or from supply chain disruption. Those are all types of exclusions that conceivably could start to be show up in D&O policies. So it might make sense for policyholders to be providing a notice of circumstances early, and that's something that people should be on the lookout for. As a matter of fact, this morning I happened to see a claim that I would argue that I'm sure is going to be argued it does trigger D&O coverage. One of the cruise lines has been sued by its shareholders, because of the price drop of the stock, alleging that pandemics are completely. There should have been planning for something like a pandemic, particularly on a cruise ship, and the failure to take adequate measures to prevent this from breakouts from a breakout within the ship taking place is the basis for a D&O suit. If the economy does turn south and there are a large number of insolvencies that result because of the shutdowns that we've had and the stay-in-place orders and the attempts to moderate the curve, bankruptcy trustees can be expected to make claims that management failed to take account of the risks that were out there at the time, or failed to disclose risks adequately, or failed to plan for supply chain disruptions. Trustees are notorious for bringing D&O claims of questionable merit. And so that's because they are looking to access directors and officers insurance. That's one of their jobs, I suppose, as a trustee. So it's likely that as time develops, there will be a significant number of claims under the D&O area.
So as an extension of bodily injury and personal harm cases, it's likely that workers' comp will also be implicated due to COVID-19. So each state administers its own workers' comp insurance program. So any analysis of workers' comp in this context is going to have to be done on a state-by-state basis. However, all states do require that the illness or disease be employment-related, meaning that it arose out of during the course of employment. Ordinary diseases of life are typically excluded. So if I have a heart attack from being stressed out about this webinar, it's not going to be covered? And you can try, you can submit it. So the general test here is whether the employee was involved in some activity that benefited the employer, and during that time the employee was exposed to the virus. So special consideration is likely going to be given to healthcare workers and first responders at this time, given the special nature of their work here. Interestingly, workers' comp insurers in at least 2 states so far have said that they're actually going to expand the benefits for healthcare workers and first responders. Those states are Kentucky and Washington. There, workers can receive benefits during the time they're quarantined after being exposed on the job. So in these situations, contracting the disease is not even required to trigger a claim. But as for other categories of employees, the compensability for a claim is going to be determined on a case-by-case basis, and causation is likely to be very problematic here. The key point will be whether the employee contracted the virus at work and whether the contraction was peculiar to that particular employment. So one way workers may be able to establish causation here will be by citing their essential status. When a worker is deemed essential, they're required to go to work during the pandemic. So the risk of contracting the disease is by definition higher than those of non-essential workers. We've deemed their work so important and integral that we need them to work during the pandemic while the rest of us stay at home. This argument, may be raised by grocery store workers and delivery drivers. And, but unfortunately, there's not a lot of precedent on workers' comp claims in the time of the pandemic. So whether it will be successful is a little unclear.
It'll also be, on workers' comp, one thought, it'll be interesting in the bodily injury plaintiffs bar, how they do the analysis in trying to decide between bringing a workers' comp claim or bringing some other kind of claim that could trigger general liability. Was the employee, the cashier at the grocery store, exposed to the virus at the grocery store, or was he or she exposed somewhere else, where if there's a deep pocket somewhere else, they may decide to chase after that? Causation is difficult in either event, but it's something that I think will be interesting to see how that plays out.
And for the insurance companies, most of their policies are going to have exclusions for injury that would be covered by workers' comp. So the insurance company's going to be in the position of trying to be the one trying to show that, no, you got this at work.
Exactly.
Well, so in light of this pandemic, we talked about all these other insurance policies. There are other specialized insurance policies that will be most likely affected. And I believe that the event cancellation policies, especially those purchased before 2020, they cover economic losses resulting from canceling an event due to a number of perils. And as we know, an event cancellation policies, as is the same with all the other policies, they're not standard, and their precise terms can vary somewhat from policy to policy. These policies are meant to ensure the event-related activity or the venue or the expenses against any cancellation due to circumstances that are beyond the policyholder's control. Some policies limit coverage to a certain specified risk, and those risks are specified in the policy. With the specified risk policies, the insured will likely bear the burden of proving if that loss was caused by one of the enumerated risks. However, not all of the event cancellation insurance policies limit coverage to a particular peril. In which case the policy in some jurisdictions, they're deemed as an all-cause policy or an all-risk policy. And that policy usually applies to all risks, such as weather events like hurricanes, tornadoes, major storms, earthquakes. You talk about wildfires, floods, the unavailability of a venue due to a flood or a fire or lack of electricity or power outages. Even if an event policy, even if an event cancellation policy contains certain exclusions, like even for SARS or government ordered quarantines. We should expect to see an increase of claims from insureds and their counsel due to the coronavirus. And in those all-risk policies, chances are they may be covered. Depending on the policy wording, it may provide coverage for event cancellations due to an outbreak of infectious diseases, such as coronavirus. As with most insurance coverages, the issues whether a particular loss is covered by a particular insurance policy will depend particularly on the type of loss. I will mention one thing with respect to the all cause, all risks, especially I know that in California right now, so this goes back to the whole notion that, really whether or not there's coverage under any of these policies will depend a lot on the facts, but most importantly on the jurisdiction. I've read that in California treats these all risk event cancellation policy to include any and all things. In other words, if it's not specifically excluded under that policy, chances are it's covered. And in those situations, the insured will then need only to establish that they experience a loss, which caused them to not have that, which caused the event to be canceled. And then it'll be the insurer who bears the burden of establishing that it is an excluded peril. So those are things to keep in mind in respect to event cancellation policies. With respect
Jolie,
to yes,
I'll just say that it sounds like in addition to all of us who do litigation on whatever side, who may have some more work as a result of this, people who draft, the attorneys who draft these policies are going to have a whole list of things to start considering going forward.
Absolutely. And jurisdiction is the key. I can't even emphasize that enough. I know we've been saying that, Dan has been talking about it, but it really is going to depend on where you're located and how that particular jurisdiction treats those types of policies. With respect to marine insurance policies, as the reported cases of coronavirus continues to increase, the global marine industry is also at significant risk of disruption. It's not certain how much they're going to be impacted. However, we know that marine insurance policies typically cover loss to the insured and indemnify for claims against the insured by third parties resulting from, let's say, operation of the vessel, damages suffered by crew, passengers, or even cargo. Policy coverage by marine insurance policies varies greatly depending on the insurance it covers, depending on the voyage, the period of time, and the vessel, depending on the type of cargo. Careful consideration of the policy wording will also be a big thing here. The one thing that comes to my mind when I think of marine insurance policies and the types of policies under that label that will be impacted will be, for example, the cargo and stock throughput policies. It is expected that with a limited workforce being available at all key points of supply chain, that will reduce the capacity to distribute or handle goods. Consequently, this would mean that cargo would be held up for a longer period of time, or maybe, redirected, through another route. And stock and cargo might be left in storage for a long period of time. So you'll be seeing more and more claims of damages to cargo. With that being said, key areas I think to focus on at this stage with respect to marine insurance policies would be, and where I think we'll be seeing the majority of the claims will be in with issues regarding delays. Although many will want to keep their cargo moving to prevent hindrance on the trading, delay during ordinary course of transit, or while goods are in storage, it could be inevitable. So depending on the language of the policy and circumstances, it is possible that an exclusion applies to exclude the loss or damage solely to delay. But that is something that I think that it's going to be big, and depending on the policy, maybe there is an exclusion for that. However, but that's one of the things that I think we need to look at. Another one is this sense of additional cost or charges that would be incurred as a result of any holdups or redirection or rerouting of the goods or cargo to an alternative destination due to, let's just say, government prohibitions. These costs usually are sublimited, but in any event, they may be covered under the policy, as well as damages to good as a result of the government orders that we're seeing that are in place now. These are all things that I think are going to be big in the next coming months. Marine policies are typically triggered by physical damage. However, given the soft market conditions, policy extensions affording non-physical loss may start to creep into policies. At least I can foresee that. And in preparing for this presentation, I was looking to see, well, how is that possible? How will this non-physical loss creep into these types of policies? And there are many opinions out there, but some examples of language allowing for non-physical damages in marine insurance policy will include stuff like extra expense coverage for forwarding charges or access to property clauses in the cargo policy. This may trigger coverage under the policy, as well as hull loss or hire policies, which may provide coverage where a vessel is quarantined or denied access to port entry. Another area is the cruise line policies. That may provide coverage where a cruise vessel scheduled itinerary is directly impacted by the coronavirus. So as you can see, none of these necessarily depend on any physical loss occurring, but there's some opinions out there that these types of languages will be creeping up into the marine insurance policy. Lastly, I'd like to talk about this notion of cyber insurance. We all know, in light of coronavirus, as more and more of us work from home or are working remotely, cyber attacks also are increasing, and the risk for getting a cyber attack has definitely increased. And you have to look at these policy forms, of course, to look at the language and to really understand what it does cover and what it doesn't cover. But just to let you know, some of these policies include coverage also for business interruption, contingent business interruptions, and or governmental authority coverage is also included in these policies. Other things to consider is, that in order for this policy to be triggered, the insured will have to show, though, that there has been some data breach or some damages to the data or network. So while this may impact cyber insurance, while coronavirus may be covered, it's still the burden is still on the insured to show that there was a data breach or some damage to data. As is the theme throughout our presentation today, because these policies vary widely, whether or not there's coverage for the claims, again, it will depend on the circumstances of a particular case and a wide array of other factors that the insured and the insurer will have to consider.
So as somebody who is not regularly an insurance lawyer, I've done tiny bit of insurance work, unlike y'all, what I'm reading here is this is something that you need somebody who knows insurance to look at. There's a lot of work to be done here. What can companies, whether policyholders or insureds, do to plan for this stuff that's coming up out of this pandemic?
Michelle, there are actually a couple of things that I think are very important. First, as we've all said throughout the discussion, the insurance policies are complex commercial contracts with terms that are susceptible sometimes to multiple interpretations, or that may be interpreted differently in different jurisdictions. It's important to pay attention to the policy terms and also for any business, gather the information that it has, identify the impact, the potential losses, document everything that's going on. And for some of these claims that are very, very complicated, such as a business interruption claim, they typically do require forensic accounting work and on both sides of the issue to do the analysis. So these are going to be very, very fact-specific claims. It's important so really the analysis, any coverage analysis in this area is going to be driven by very difficult and very close issues of policy construction and interpretation, and how those policy terms are applied to a complex and developing set of facts. That's going to take very, very close analysis, very careful analysis. And it's important, I think, as we're learning that this is the new normal, to learn as quickly as possible about and to really do the work that's necessary to assess whether or not there is coverage available.
So I'll say from the insurance company perspective, I think as to the business interruption coverage, they're likely to drill down on that physical loss requirement. I think that the insurers are definitely going to be watching proposed legislation, as there are some proposed state bills right now that are trying to mandate coverage for COVID-19 related business interruption claims, despite any exclusions, including the virus exclusion in the policies. So insurers may be able to argue that these bills are essentially forcing them to rewrite their contracts. The insurers are going to want to keep an eye on the most up-to-date scientific knowledge about the virus and use that in strategic ways, especially science that goes to that physical loss or damage. And lastly, as for the litigations, I'm sure the insurance companies are going to keep an eye on those and try to be sure to present consistent defenses. And they're definitely going to want to avoid jury nullification and the creation of bad law.
If I could just, there are no easy answers here. For anybody involved in these issues, there really aren't any straightforward answers. And dealing with the fallout, the insurance implications of this pandemic, it is going to take, for businesses, for insurance companies, careful analysis and a careful legal analysis of how the particular circumstances apply to these policies that really weren't written with something like a viral pandemic in mind. It's going to take creative interpretation and hard work by the advocates for everybody involved.
Well, and I think there's been so many interesting issues raised, both just on the insurance law portion of this, but also on a lot of what I'll think of as the trial geek aspects. I mean, we have companies that have policies that insure locations in multiple states. What are the choice of law issues? I think you all have highlighted choice of forum issues. I mean, there's a lot of things that are at play here. And I'm not sure we could have, I appreciated when Joe said that, they should have planned for this pandemic in the context of the D&O policy. Well, I wish I'd planned for it too. I might have had another person at my house that I could at least do a puzzle with, right? It's from a layperson's perspective, saying you should have planned for this. I feel like the jury would be like, sure.
We're going to be talking about these issues for a long time to come, I think.
Now, we are close to the end of our time. We have questions. Do we all want to stay on and take the questions, or should we push those out, our answers out to people later? Where do you all at? Where we are at our time? We still have 65 people watching.
I'm happy to take questions.
We have some really interesting ones. So,
like I said, as long as they're ones that we know the answers to.
Well, I think there might be a good place for some discussion here. So one of the questions was, how are the policy coverage arguments influenced by a business's ability to perform some of its work? For example, takeout only, when the business usually generates 90% of its income from dine-in. And I'll add the wrinkle, now our restaurants, at least in Texas, can deliver alcohol, which I know is usually a big portion of revenue. So they're getting more money than they normally would get from takeout. But so thoughts?
That's part of the business interruption analysis. I mean, the way damages are calculated under a business interruption extension are the trying to do an analysis of what income was lost because of this particular loss. That means very often it's a matter of comparing multiple years' revenues to say, okay, in April of 2020, this is what my business was. In April 2019, this was what my business was. In April 2000, and going back and looking at how it has impacted the income of the business, and then factoring in, the payment of rent and the like. And there are some restaurants that have had to let some people go, but then hire additional people to do different kinds of things. It's all of that and the costs associated with changing the way that one does business. All of those are components of a business interruption claim, so that even though there is some lessened business taking place, there's still the possibility for claims here, but it becomes a very difficult accounting and analysis issue to determine what the loss is.
Yeah,
Like
Dan said, assuming that there is going to be coverage for the claim, there are going to be some CPAs out there serving as expert witnesses that are going to have more work than they can handle for, I would say, the next 5 or 6 years.
I'll just point out that in some of the cases we talked about, the plaintiffs did make a point to describe their restaurants and essentially their unsuitability for takeout. French Laundry described the 9-course chef's tasting menu that they serve. And Oceana Grill mentioned that they have a 500-person capacity. So I think that they're trying to drill down on this issue of, okay, technically we can be open, but how do we realistically do takeout of a 9-course tasting menu?
Although Alinea in Chicago is doing takeout. So
are they doing what they're famous for, or are they modifying their menu?
They've modified it to a reduced sort of set. Here's your meal. It's 3 courses. You can take it out, as opposed to the full evening of dining. But there are costs associated with that, and so there really are. It's a fact by fact business income analysis is a very fact specific analysis.
Right, and some of the actions that these businesses are taking are to sustain their businesses. They might be things that undercut their insurance claim, but mean that they are going to be here for us when this is all done, right? I mean, there's business issues versus insurance issues, and those might not line up exactly.
It's entirely conceivable. They sometimes they do line up, sometimes they don't. It really, because the business interruption coverage does factor in the costs you've incurred in order to mitigate your loss. That is something that is covered in part under a business interruption coverage extension. So that's part of the analysis, whether or not you've taken steps to mitigate.
And Jolie, I saw you smile when I said that. Was there a point that you wanted to make?
Oh no, I mean, absolutely. I mean, I agree with you. And I agree with Dan. Dan couldn't said it better himself. It's really gonna depend on an analysis on both ends, which is why when we discussed the case where we said there was a flat out denial, that's another thing that, as we're here planning for this unknown, that a lot of insurance companies need to take into consideration that if they're going to deny these types of claims, that make sure that when you send out your declination letters, that your declination letters specifically explain and conducts an analysis of what you've reviewed, what you have considered, and why your position is what it is. Those are all things that are going to be very helpful and will try to eliminate any issues of bad faith later down the road.
It is interesting. Somebody did say, do we think there's going to be an increase in bad faith claims in general as a result of this? Thoughts?
Now there's going to be an increase in claims, which I think means there's going to be an increase in bad faith claims. I don't know that it will be disproportionate in this circumstance than it is in others.
Another interesting question comes from somebody I happen to know has an interest in a restaurant, and he says, do you think that the order in California was drafted with insurance in mind? You know, was it sort of a friendly order on behalf of the government to cause coverage to exist for many more than otherwise might have been the case? That was in the French Laundry case. Thoughts?
It would not surprise me that it was. I've been involved in cases, hurricane cases, in which stay away order, casino closure orders were written very much in mind of whether or not they're going to help the local industry's insurance coverage claims.
Yeah, I echo Dan 100% on that. It's unfathomable to think that they didn't take that into consideration as they were preparing that order.
And you actually have a background in working with restaurants. Do you think they were lobbying for that, Tiffany?
You know, California is a special situation. In particular, California is special for many reasons. You know, they're very employee friendly and friendly to local industry. So, you know, I do think it was taken into account and drafted in a way that could be interpreted most favorably, or at least to create a whole lot of litigation.
And then another question that came in that is interesting is, you know, what's the benefit of filing a bare bones complaint like we saw in Chickasaw or in Big Onion? Is it to get first in line? Like, why?
Well, that may be part of it. Another part of it may be that as long as the complaint meets the requirement to avoid a dismissal, you may also avoid an early dispositive motion that would allow you to get into discovery. So that's a litigation strategy that, you know, obviously can backfire, but it is one that I have seen before.
Well, it seems like we've covered most of our questions. Anything anybody on the panel wants to say before I wrap it up?
I'd just say that for the attorneys out there that are going to be asked to look at these claims from insurance companies, you know, make sure you read the policy and know what endorsements are on the relevant policy, and don't skip the choice of law analysis, even if it takes you 3 minutes to know where the insured is, where the policy was issued, where the loss was, and what the policy may have to say about it. Make sure you at least do that analysis, and make sure that you give your clients advice based on a correct choice of law.
I'd say that sounds like good advice on no matter what side you're on.
That's pretty that's universal advice, I think. No, absolutely, it's good advice for anybody involved in these issues.
I mean, choice of law can be super important. The court doesn't raise that sua sponte. That's up to the litigants.
And it does make a dramatic difference, given how different states interpret different policy provisions.
Well, panelists, I really cannot thank you enough. This came together, I think, in about a week. So everyone who's listening, I'd like you to know, again, NAMWOLF is here. Our law firms are here. If you need help in these kinds of, with respect to insurance issues or other kinds of claims or trial issues, we've got a lot of law firms that are working from home and here for you. Thanks for being here, and we'll see you at the next webinar. Thanks, everybody.
Thank you all. Thanks, everybody, for joining.
Thank you.